Hello, everyone. Thank you for being here today. My name is Chris Wickman, and on behalf of the Board of Directors of the Ingham County Bar Association, I'd like to welcome you to this presentation entitled Civility Manners. I'd like to thank our partners of the ICBA pictured behind me. I'd also like to thank the Michigan chapter of the American Board of Trial Advocates for partnering with us on this event. This event is being recorded, so make sure that you have your camera and audio off if you do not want your likeness or audio to be captured. If you'd like to ask a question, feel free to put it in chat or private message to me, and I will try to break in during the presentation when appropriate to ask your question. There will also be time for questions at the end of the presentation, whether you can either do the same, put your question in chat, or unmute yourself and ask. We are very lucky today to have Mr. Thomas Behm and Mr. Robert Riley presenting today. Mr. Behm is an attorney with the Gruel Mills firm of Grand Rapids. In his work, Mr. Behm has represented seriously injured individuals in the areas of personal injury law, medical malpractice, product liability, and construction site negligence for over 30 years. He also serves as a facilitative mediator. He's a past president of the Grand Rapids Bar Association, past chair of the negligence section of the State Bar of Michigan, and past president of the Michigan chapter of the American Board of Trial Advocates, among many other accomplishments and activities. Mr. Riley is the founder of Riley and Hurley PC, which is a litigation-based law firm out of Southfield, serving a wide variety of individuals, professionals, corporations, and healthcare providers since 1994. He also serves as a mediator. Mr. Riley is currently the chairperson of the negligence law section of the State Bar of Michigan, and has also served as a past president of the Michigan chapter of the American Board of Trial Advocates, also among many other accomplishments and activities. So without further ado, I will go ahead and start sharing my screen and turn it over to them for their presentation. Thank you very much, everyone.
Thanks, Chris. Bob and I are thrilled to be here. This is a program that we've presented in the past entitled Civility Matters. In the past, it's focused primarily on audiences consisting of law students and young lawyers. We've expanded this to cover old guys like us and everybody in between. And so we're excited to talk about civility. We want to start out our program by asking perhaps a rhetorical question about whether or not there really is a civility problem. And if you can click ahead a couple of slides. There's our question, and we want to look first to a video clip of an NFL football game, just to give, I think, all of us a sense of what civility really looks like today in the real world and outside of the courtroom. Perhaps that will give us a little bit of insight into some of the problems that we all face with civility in our practice. Go ahead.
Set it for you real quick. LOB. All right, and Joe, back over to you. Joe, thank you so
There's that perhaps captures a little bit of what we're all used to seeing and hearing. But this next quote is involving a case entitled Crawford versus J.P. Morgan. It's a 2015 case out of the federal court in New York. Mr. Crawford is a plaintiff in the case. He also happens to be a lawyer, and he's upset with J.P. Morgan because they sold his elderly mother an annuity that he felt she didn't need. And when that was brought to their attention, they immediately reversed the transaction and credited her account the money that had been spent for the annuity. But in the meantime, Mr. Crawford was not happy with that and filed suit in federal court seeking $2,000 in lost interest. One thing led to another, and he became very upset. And when they wanted to take his deposition, the attorney for J.P. Morgan showed up to take Mr. Crawford's deposition, and Mr. Crawford showed up with a pepper spray can and a stun gun, and promptly told counsel for J.P. Morgan that if he was out of line, he was going to pepper spray him and stun gun him. And to demonstrate that the stun gun worked, he shot it off about 3 feet from him. A motion was brought, and the court ruled, as you can see here on the slide, it was perhaps the most outrageous behavior that I've ever heard of in my life by an attorney. That was, believe it or not, 2015. Many of you, I think, have probably seen articles and things talking about the lack of civility in our profession. It's most disturbing. This was the front page of the ABA journal, Keeping It Civil, that was out a few years ago. And then you may have seen some other publications recently from the ABA journal and the Wall Street Journal, where they're talking about civility and how to keep it under wraps, or incivility under wraps, and how to promote civility. So it really, I think, almost goes without saying that there is a civility problem here in the legal profession. But what does it really mean to be civil? We've got a little slide here, and maybe I'll turn it over to Bob here for a minute to talk a little bit about what does it mean to be civil and the difference between being a zealous advocate and just being a zealot themselves. Bob?
Thank you, Tom. Chris, thank you for the introduction and the opportunity to speak to this group. Thanks is a novel concept, isn't it? It's not appreciated very much in the legal community these days. And I think we've reached a point where we need to pause and recognize that our advocacy is one thing, but inappropriate behavior is another. To be a zealous advocate, as the slide suggests, is to be, in effect, passionate or impassioned or devoted. These can be construed as positive things. To say someone's an enthusiastic attorney can be a compliment. But the problem is, interpreting the word zealous is almost a license to be rude, to be insensitive, to speak with venomous tone. And it occurs in a variety of settings. Please do not think that my remarks are limited to the litigation world. I suspect that my background and Tom's background makes us appropriate individuals to talk about trial attorneys. But I can assure you it goes well beyond the trial attorney community, that those who draft documents and are practicing commercial law with contracts, for those who are doing labor work and perhaps negotiating collective bargaining agreements, for those who are in a probate world where there are contested issues. A bankruptcy, for example, invites differences of opinion. And in all walks of life, I suppose we should recognize as attorney that there's two sides to every story, and sometimes 3 or 4. And recognizing and having respect for our profession, which is designed to advocate and advocate aggressively for our clients, does not mean that we reduce ourselves to a primitive level and threaten someone with a stun gun, or scream and yell at someone during a deposition, or even simple things, failing to grant courtesies, or to recognize scheduling difficulties, or to work within the limitations of what some lawyers can do for their clients. Some lawyers might not be prepared to offer the full range of services. they shouldn't be diminished if they're willing to say, hey, time out, I need additional help and assistance. Can I have an adjournment while I secure additional counsel? Oh, excuse me. Whatever it might be, zealous advocacy means important and critical points are emphasized. It means that that which is necessary for the core issues in a dispute, a contract, or whatever, are emphasized, but that the decency that is necessary to be a zealous and effective advocate is what we're here to talk about today. Our next slide, please. What does it, go ahead. All right, this is a cute cartoon. I don't know if anybody saw it. What does it mean to be uncivil? Can everybody see that? I hope so.
Yes, we can.
Good. So the point here is at the end of the cartoon, with all due respect. And then the point is, let's go over that concept again. What does respect mean? Let me give you an issue that occurred in my life professionally not long ago. I was asked to comment on misconduct that occurred in a case that I was mediating. The plaintiff was blind. An argument ensued during the deposition of someone else, but the issue of blindness was essential to the case. At one point, the attorney for the blind plaintiff got angry with the defense attorney and said the following: "Thank God my client is blind and can't see your fat, ugly face." Pause for a second. First, that had nothing to do with a core issue in the case. Second, it could not be more demeaning or derogatory. And third, it was based on the absence of any principles. What principle that might bind a lawyer to appropriate conduct could even remotely support or endorse, much less tolerate, that kind of demeaning remark? These remarks are not limited to a deposition and an angry moment when something doesn't go the right way. How many of you have pushed send on an email and regretted it? Correspondingly, how many of you have received an email which would suggest that you're dumb, you're stupid, or illiterate? In another one of my cases, a lawyer sent an email to his opposing counsel and asked rhetorically, "How in the world did you possibly get through law school? You are an effing," spelled out, "idiot." Again, that's just pushing send when you should pause. And it doesn't have to be that dramatic to be offensive. The point I'm making here, and the point that's central to us, that as we explore the absence of civility, please recognize that it's becoming a crisis, that the pandemic over the last almost 2 years plus is a creature that has caused considerable pain to the legal profession, particularly among our younger lawyers who have yet to experience interaction with lawyers in person relationships with judges as they preside over a matter, whether it's motions, trials, or whatever, who have yet to engage with people in their own office on a day-to-day basis. The skills and the techniques that demonstrate civility don't seem to be evident. This is becoming far too common. A regular question now asked is, what do we do? How do we address this? And where do we go from here if civility is truly a problem? And what can be done in the future to address this systemic issue? Tom?
Chris, can you go ahead a couple of slides for me? This is a funny, there you go, okay. Here's a quote out of the Kim v. Westmore Partners case that I thought was appropriate. It talks about the fact that the legal profession is rife with cynicism, awash in incivility. Lawyers and judges of our generation spend a great deal of time lamenting on the loss of a golden age. And the judge goes on to say it's time to stop talking about problems and act on them. For decades, our profession has given lip service to civility. All that's gotten us is tired lips. And we've been reluctant to do anything more. And the suggestion here is going to be, well, the teeth now are going to be sanctions. And we see sanctions becoming a bigger and bigger part of our profession when people do not act civil. And I think we're going to continue to see more and more of that, and we hear about it, and we're going to talk about it this afternoon. But it is becoming a bigger and bigger problem. So if you go to the next slide, Chris, we asked the question here, what is the purpose of this program? And Bob and I have kind of put down a little bit of an outline, and here it is before you. It really is, we're really here today, rather, to talk to you about a lawyer's roadmap to civility, or for civility. We want to talk first about principles of civility. Where are they? Where can they be found? What is out there in the real world that you may want to refresh yourself with, or have at the ready if you need to provide those to a person who sent you an email that doesn't quite sound like a love letter. And then the second part is structuring ourselves so that we can adopt principles of civility. What Bob and I mean there is, what do we need to do, perhaps in our own practice, with our staff, in our own mind, when we know we could potentially be in a situation where the dialogue could be heated? How are we going to respond in those situations? How do we begin to put ourselves into positions where we do not become uncivil toward one another? There's typically always two different ways or more to ask a question. Are we finding ourselves going to a disrespectful way of asking a question or making a point or a statement? And what should we be doing about that? So Bob and I are going to talk a lot about how do we structure ourselves so that we adopt principles of civility. And then finally, the third part of our roadmap talks about applications, outcomes, and benefits from civility. And we think there are a number of strong benefits to being civil. And we're going to talk a little bit about that. They include things like promoting good relationships, helping put together a network of people that you can rely on, and people who may refer you cases in the future. It also is expensive to be uncivil. It truly is. If you're fighting off motions constantly, if you are getting sanctioned, that typically cuts into your bottom line, not to mention the fact that you oftentimes lose clients and your reputation takes on a huge hit when you look at it from a global perspective. And when you look at it in terms of how much is it going to cost you as an individual to be uncivil. It just requires us to step back and look at this issue as we go forward. So we want to first talk about what principles are out there that give us as practitioners some idea as to how do we behave civilly, and what do those principles include, and what do they say? Bob?
Thanks, Tom. Let me begin with this observation that the program that we're putting together tonight is designed to give you take-home value by talking about principles, by emphasizing some structure to your professional practice, And by asking you to focus on applications or outcomes or benefits, we're attempting to change the discussion about civility to some practical way you can evaluate yourself, evaluate lawyers in your law firm, evaluate the lawyers that you work with. And let me emphasize that this does not just apply to the lawyers themselves, but it applies to our judiciary, and that our concepts here are applicable to all. The beginning step in this analysis or self-evaluation is principles. The outline is dependent upon beginning with principles. And there's really a number of sources that we rely on when we think about principles. It's easy, for example, to look at the rules of professional responsibility and to review and analyze them in courses in law school that emphasize professional responsibility. But I would submit to you that that's just a start. The Michigan Supreme Court has recently become involved in this issue. It has standards. The federal courts have standards, and various organizations have standards as well. One, for example, is the American Inns of Court. And before you is a professional creed that invites one to consider that which is important in the rule of law. And that's by treating the practice of law as a profession. And indeed, I believe it's a special profession. And that recognizing this is upholding the highest standards that are applicable to professionals, so that integrity, dignity, courtesy are all part of that which is civility. And to state, as this creed suggests, that you will honor the requirements and the spirit and the intent of applicable rules or codes of professionalism is indeed important. Next slide, please. As you know, Tom and I are members of ABOTA, the American Board of Trial Advocates. It's an organization which at its core supports the key goals of professionalism and maintaining jury trials. Our behavior and our integrity is important, and the code of professionalism that this organization has adopted is not only applicable to potential members, but to those who are actually incorporated within the body of membership. And the obligation of all concerned is to apply these principles to our practice. Next slide, please. The Michigan Supreme Court, as I mentioned. The Michigan Supreme Court and the State Bar of Michigan are currently involved in extensive reviews of professionalism in Michigan. And one of the initial steps was for the court to adopt civility standards. These are applicable to all. And while they speak in generalities, they are a critical step. Recognizing the problems we face, the Supreme Court has intervened, adopted these standards, and they're important and significant for us. Correspondingly, there are standards in the Eastern District of Michigan and the Western District of Michigan. And within the federal courts, these standards apply to all who appear before the judges in those venues. Let me wrap up this overview of principles with this observation. The golden rule. Treating one another the way we wish to be treated ourselves is a simple but profound way to look at underlying standards for civility. And if one asks oneself, do I do that? Do I treat others the way I want to be treated? Am I sensitive to that which would bother me in my dealings with others? You can apply that generality or the very specific standards we just went through, whether they're organizational codes, whether standards by courts, whether they're specific venue-related rules that are required of those who file appearances. It makes no difference. It's having a sensitivity to principles, which becomes the starting point for our analysis and evaluation of ourselves. Tom?
Thanks, Bob. Chris, could you go back just a couple of slides to the Supreme Court order? I just want to point this out for folks who may not have seen this. You have a couple more, one more back, I think. There you are. This is the Supreme Court order that Bob was talking about. It was issued back on December 16th, 2020. So a little over almost 15 months ago now. If you do not have a copy of this, you can certainly contact Bob or I, and we'll provide one to you. But this is an order that set forth the guidelines that all of us should follow, including members of the judiciary. And if you do not have a copy of this, I suggest you get one and take a look at it. It's not extensive. I think it's about 7 pages long, but it talks about things like cooperating with one another in terms of scheduling matters, engaging in good faith discussions. And I think here's some of the bullet points. If we go down the fourth one, we do not engage in disparagement or attack of others involved in the judicial system. I mean, that's really remarkable when you read through this and when you see what's really going on. And you want to be armed with these principles and know the standards that you're required to uphold and have a good idea that if people are amiss or if you are amiss of these standards, that there could be consequences. And yep, if you'll just jump ahead a little bit, Chris, that would be great. There we go. And here's the, yep, there we go. This is the, here's where we want to be. So we talked about principles. Now we want to talk a little bit about structuring yourself to adopt these principles of civility. And when we talk about structuring ourselves, what we're really talking about is, and we'll get to a few examples here, what we're really talking about is how do we put ourselves in the proper frame of mind to promote civility? How do we foster integrity within our practice? Are we conscious of what we're saying and doing and considerate of others in our demeanor, in our tone? And really what we're talking about is self-awareness. How do we become more aware of what we're doing and what we're saying? How do we prepare ourselves perhaps to respond to what we may consider to be an uncivil remark? Do we lash back quickly with an equally uncivil remark? We've all been in situations like that where we've been addressed improperly. I'm sure we've all had what I call nasty grams sent to us. And I've adopted what I call the 24-hour rule, where after I get an email that probably shouldn't have been sent, I think about it for 24 hours and then I respond. Many times I respond with, got your love note, could you pick up the phone and give me a call? I have found that oftentimes what might end up being minor skirmishes on email can really be worked out with a phone call. And I think those are some of the things that we need to remember. After all, the practice of law, first and foremost, is about relationships. And it's about maintaining good relationships with courts and with people that we all work with on a regular basis. And yes, we can get into heated situations, but I think we need to recognize that when that occurs, you need to be aware of it. Self-awareness is absolutely critical in being able to practice civility at its highest level. We want to spend just a couple of minutes and look at what I think we can all agree are some examples of incivility, and we're going to start out in the world of depositions. So if we can go to this next slide. Conduct, here we go. This is a
Contents of your
deposition, a
computer.
real world deposition.
With regard to the searchable index that DuPont gave you, especially the field of addressees that say none, is DuPont's exhibit number 1. Is DuPont's exhibit
Counsel?
number 1.
I can't work like this.
Calm down. Come on, take a,
Counsel,
take a Xanax.
first of all, you have no right to even claim an exhibit. It isn't your deposition yet. That's number 1, counsel.
So you've taken it off and torn up the exhibit.
Sir, you're not going to touch it. How dare you? You are going to go before the Bar Ethics Committee on this one, son. We're going to quit the deposition right now for the day so that you can rethink what you're doing.
Bob?
Oh, just a day in the life of litigants, right?
All right.
So depositions are a perfect illustration of the problems that we're currently facing. They are difficult enough in person, but the remote world we're coming through right now is impersonal, it's distant, it's seemingly far removed from the people that are involved. And that which we just saw in the live deposition is becoming more and more common in what's known as the remote video deposition. So the illustration that you just looked at causes one to pause. We're asking you to invoke structure in your practice. So the illustration you just saw focused on exhibits. Well, exhibits can be a difficult subject matter. Were they disclosed in time? Are they a surprise? Are they relevant? Are they somehow appropriate for that which the witness is being called upon to address? Are they so voluminous as to be virtually meaningful for what would hopefully be a relatively short and focused deposition? Any one of these issues invites difficulties, frustrations, anxiety, and the like. So when we recommend to you that you think about applicable principles and then develop professional structure for what you're doing, the deposition becomes an ideal example. Do you know your opponent? Do you know what it is about your opponent counsel that sets them off, or what buttons to push? We're suggesting that as you go into that deposition, you think through that which structures the best and most efficient way to conduct your examination or to defend your witness and to advance the needs of the case so that your client has the best possible outcome. Now that's hinting at point number 3, obviously, the outcome, but how you structure yourself and govern yourself by principles in planning and preparing for a deposition reveals a lot about who you are, the integrity that you have, and that which fosters a civil and collegial experience. Frankly, I would tell you that if you are adopting core principles and you have structure and you keep it in mind, it will be second nature for you. You won't even think about the unthinkable and raising your voice, yelling or hollering, tearing up an exhibit, for example. It just will not be part of who you are and what you have taught yourself to do. Let me illustrate, however, what happens at a deposition when you don't follow the structure that you have designed and the like for a deposition. A prominent defense attorney, a member of the American Board of Trial Advocates, had a client being deposed, and he elected to abandon known principles, the structure that he had used throughout a long career, to text messages to his client during the deposition to help answer deposition questions without alerting the opposing attorney or anybody for that matter that he was doing this. Now just think through what I just said. This is an excellent attorney who is text messaging during a deposition to the client to get the client to answer the questions in an appropriate way. Now, we're talking about civility, but integrity is a key component of civility. And this certainly was not a civil and appropriate action by this attorney in attempting to coach, teach, modify, and rig, I say rig, answers to deposition questions. Now, the moral of this story is that this individual became a former member of ABOTA, and we asked him to resign or face expulsion. Why? Because principles are really important, and structuring yourself to honor those principles is critical. And if you think through it, how in the heck could you get to texting answers to your client to rig the testimony in an appropriate way for whatever your cause is? Appropriate only because you're fixing the answer, not because it's the right thing to do. Please don't misinterpret me. This is a core example of abandoning principles, abandoning what you've done for years, and frankly, ending your career on a sour note. You had to structure this activity in contrast to that's how you had structured your activities for the length of your career. So structure has a number of components to it. It's how you behave, it's how you do things, it's what you do. And we're urging you to think through the principles that govern attorneys. And in this deposition example, recognize that it's more than just losing your temper. It's embarking on a course of conduct that you've thought of in advance to misbehave or do the wrong thing. This is what we urge you to be sensitive to in your own self-evaluation and those of others who are important to you and your firm.
There are also times when, we'll get to a witness here in a minute, but there may also be times when you know you're going to be up against an opposing attorney who is going to make it difficult. What do you do in those situations? How do you avoid what we just saw on the tape? There are a number of examples that we can all think about where things really went awry. And when we think about how do we combat that, how do we put ourselves in a position where we decrease those situations when you really have someone on the other side of the case that is difficult to deal with. Suggestions that we've come up with may include, instead of having a status conference or scheduling conference at the start of a case where we simply submit dates to the court and we get a scheduling order in return, you may want to attend that scheduling conference in person. And you may want to address concerns at the outset of the case with the judge due to prior involvement that causes you concern. I've seen that done, especially in federal court at a Rule 16 scheduling conference, where someone simply came out and said, you know, I'm concerned about how these depositions are going to go, Your Honor. This is what I've experienced in the past. Other people have scheduled depositions at the courthouse. That can be an effective way to make sure your opponent is engaged in good behavior. But it also requires each of us to structure ourselves so that we also engage in that same good behavior. Bob and I both strongly feel that if you hold yourself to a high standard, most of the time, more than most of the time, your opponent will do the same thing. But there's also a problem that we're going to look at here next. What do we do when our witness perhaps is awry? Take a look at this video.
Don't nail me on that.
Did you obtain prior approval from the association for that shed?
Actually, I'm assuming you people have gone to the files, the building files, and all the other necessary files. If you haven't, you're a fool. Actually, it was an accommodation that we spoke about, and we never made it. It was an accommodation, and we never made a formal application about it. And if you take exception to it, I'll put it back where it was, which is right on the killer's line. You want me to do that? I'll be glad to. Today, tomorrow, next week, that's where it was. It was on the survey. It's on the survey. And I gently removed it. Am I going to be punished for it? Good. I'll put it back.
Was that a yes or a no?
It was a fuck you. What's your question?
So in a situation like that, we need to be mindful that we cannot engage in conduct that would not be appropriate in the presence of a judge. I think that's a very sound principle. It's one that ABOTA includes in its standards of professionalism, but we really all need to adopt that. And you could see how this deposition started. The question started out with, is that the kind of shit that you do? And you can see how the witness responded, and it deteriorated from there. This is just one example of witnesses engaging in bad behavior, but it certainly doesn't help matters when the questioning lawyer is using profanity to phrase the question. Simply not appropriate, and it falls far from the structure that we all want to have in our lives. The other thing it reminds us to do is make sure that our witnesses, our clients, are engaged in professional conduct as well. And that's also a big part of being a civil lawyer with integrity, is you need to impress that upon your clients, because that bears directly on the type of lawyer you are and the type of reputation you're going to gain in the legal profession. Bob, any thoughts on witness unprofessionalism?
I do, Tom. I'm going to give another example. The witness, my client, gave testimony about what occurred during the medical care and treatment of the patient, now a plaintiff suing him. And he made a description of what records, if any, would be available, and took the issue that these records would definitively identify a date that was critical to the chronology of care. And if you accepted the physician's view, that date would be dispositive of one of the issues in the case and he would prevail. And as I listened to the testimony, something didn't register, and I couldn't figure out what it was. So in the aftermath of the deposition, I consulted the office staff to assist me with the chronology. I wanted information that would help me understand that which would document the sequence of events and what, if anything, was contained within the doctor's records. And in the course of doing so, it became apparent that a different chronology existed, and that chronology was highly favorable to the plaintiff and the care and treatment she received. And as I explored even further, I found evidence that the doctor had actually initialed one of the key pieces demonstrating that this different narrative about what the timeline was actually turned out to be. So when I confronted the doctor with this information, he confessed to me that he knew this in advance, thought it was critical to his defense, and in essence admitted that he lied. So now my credibility is on the line. We discussed the issue, and I told him that he had a choice, that either I disclosed this in some manner or form, or that he would secure a new counsel. We also had an insurance carrier to deal with. And at first, the carrier thought that I might be exaggerating or perhaps amplifying on something that might be more harmless. I told them that that was not an option, and I repeated that I was not going to remain involved and perpetrate the false testimony and make an issue of it. Fast forward, I filed a motion to amend my pleadings to admit responsibility and to admit that the version of events that were spelled out in the complaint were accurate, and that we were accepting responsibility for that which transpired due to this false narrative and its impact on the case itself. I have to tell you that that is a startling moment in the life of a lawyer. I never disclosed precisely that the doctor lied. I wasn't required to do that, but I was required to admit that which was contained in the complaint and accept the consequences with my client for what occurred. The point is, I second guessed myself for years that I had not picked this up in advance. And maybe I could have, and maybe I should have. And for that, I'll never know with certainty. Now, I'm not the most calm person, and I've lost my temper in depositions. And I've probably done the things that we're talking about not doing here in this context. But structure for me meant that the principles governing lawyers require disclosures of things as serious as what occurred here. And we did that. And everybody survived. The case ultimately was settled, and we moved on. But thinking through principles and thinking through how you structure yourself for events that occur, whether you anticipate them or not, are central to this process of civility and all that is included within the word civility as you evaluate what you're faced with and what you're going to do with those difficult moments with your clients. Anticipate, if you can, misbehavior. Anticipate what to do, even if you don't anticipate it. In other words, what would I do if? And this is all part of, I think, the growth of a lawyer and taking civility to where it belongs in terms of your practice and its structure.
Let's go to our next slide, Chris. Thanks.
Before we move on, there was a question in the chat with regards to how you would handle, or at what point you would step in, or how you would step in with the video example we last saw.
Tom, why don't you go ahead?
So if you've got a question that is being framed the way that was being framed with profanity, I would stop right there and object to the question and likely instruct my witness not to answer a question that says, and what did you do with the shit? That I think stops the negative tone right from the get-go. And we've all been in those situations where people have started to lose their cool. I mean, a lawyer, and the questions start to deteriorate. And I will oftentimes ask for a break and then ask to speak with opposing counsel right away before it gets too far afield from being meaningful. And oftentimes, in my own experience, that has proven to be a meaningful way to nip it in the bud. I look for situations where something's going to go off the track early on, because we all know one bad act oftentimes begets another, and that's when it gets to be a real problem. So I think the sooner you can nip it in the bud, the better it is. In my own experience, I had one situation where I had to take a break and I had to call the court. Now that's only happened once in 35 years, but as it turned out, we had the question and the answer, and it was an answer that I thought was inappropriate. And we read that back to the court, and the next day we were taking that deposition in the jury room of the judge's courthouse. And boy, did that send a message quickly. I think that's a judgment call. You've got to look at the tenor of the case, how heated is the battle, what are the personalities of the people involved. But I think it's important to address that early as opposed to late. And whatever you do, structure yourself as best you can not to take the bait. And if your client is there, I always instruct ahead of time, do not get upset, do not take the bait. And if it's really your client who's amiss, then I would ask for a recess and directly speak with my client about it. Bob?
I agree with you. Knowing when to take a break, to pause, to calm a difficult situation is important. And pause. I would suggest, even if there's an objection to pausing, when obscenities arise, you've gone way past any acceptable line. The break probably should have occurred earlier, before obscenities actually occurred. So when things start to go south, when anxiety, temper, or argumentative things emerge that are outside any kind of tolerable range, say, hey, we're headed down the wrong path. We need a quick timeout. Let's pause. Tell your witness to step out, talk to opposing counsel and say, hey, don't mean to go this way. I know you don't mean it. Let's nip this in the bud. Conciliatory statements are required. Making sure that you treat the other lawyer like you'd like to be treated yourself if you did this kind of thing, and say, WTF, what are you doing? No, you don't do that. Instead, you say, hey, we all have these moments. I get it. We're going to take 5. We'll be back. I'm not going to talk to my witness or anything other than to remind my witness to behave, and we'll go from there.
Good. Next slide. This seems to be more prevalent, at least in my practice, and I'm sure in many of yours, and that is, what should you do if you receive an argumentative, nasty email or letter or voicemail from your opponent? It seems to happen a lot. Here is one, I should say, at the outset, Bob and I have been provided numerous examples of this. This was one that we thought we would use in large measure because it comes from someone far from the state of Michigan. They're in Illinois, as you can see at the bottom. But this is not uncommon, and this is a very garden variety type of email that we've seen, unfortunately. And it reads, as you can tell there, "I hate your effing existence." And it goes on to say in the middle, "I have never met in my limited basis a more despicable self-made effing slime bag, and I piss on your existence." Well, when you receive, and it gets worse, as you can tell, when you receive something like this, obviously the impulse is to respond with an equally offensive punch back to their head. And again, we implore you, that is not what you want to do. Again, we're back to structuring ourselves so that when we get something like this, we can respond in a meaningful way. Obviously, they've crossed the line. They're engaged in conduct that's very unbecoming. And if this is sent, when you think about it, it has a high probability of making it into the court record as an exhibit on some motion. So there's a high likelihood that this is going to come back to haunt you. What can we do about these kind of notes and these kind of letters? Well, we need to recognize, first and foremost, do not send this out, because name calling, things like this, as you can see from the slide, often ends up in sanctions. And then before you know it, you're the subject of a lot of discussion in your legal community or throughout the state, depending upon what it is that you've done. And someone who has spent their life building a good reputation within a few short minutes has caused that to completely fall apart because they've been personally sanctioned for improper misconduct. And then, of course, the next thing that happens in the age in which we live is the letter that was sent out, or the email that was sent out, which is the subject of the sanction, now becomes circulated amongst members of the bar, and what you acknowledge shouldn't have occurred has now gone all over the legal community. You're embarrassed, you feel bad, or worse. I would suggest that if you have engaged in that kind of conduct, and sometimes we all have, that you respond immediately with a letter of an apology. Remember, you want to preserve your reputation, you want to preserve the relationship with folks in the legal community, and engaging in nasty grams like this only guarantees that you're going to be the butt of a lot of jokes. And that is not the kind of attorney any of us want to be. Bob?
Let me give you an example of a way to structure responses. Think of everything you send by email or write in correspondence as a potential exhibit. Is that what you've written, composed, or responded with of exhibit quality? If you think it through that way, your structure will be, what would happen if that which I have written makes its way into the courthouse and it's an exhibit and it is addressing the issues that I created by writing it in a particular way. If you use that as your litmus test and pause to think, okay, I've received this nasty, idiotic letter that demeans me, bothers me and makes me angry, and you pause and you don't push send and you wait 24 hours, when you craft your response, make sure that it's a response that you would be proud of as a potential exhibit, and that others who read it would recognize not only your civility, but the power to ignore, in most instances, that which occurred in the nastygram and elevated you to a higher level. If you structure yourself in such a way, you meet the standards or principles that you've adopted for yourself, and hopefully the outcome you get from it will be a positive one.
Next slide, please. This is just a principle that ABOTA sets forth with respect to civility and professionalism, and it's a good one. Advance the legitimate interests of my client without reflecting ill will they may have for their adversaries. And there are oftentimes situations where the adversaries have absolute contempt for one another. Those are situations where you really do need to try and de-escalate that tension. And if you fall prey to the ill will toward one another, it's only going to come back to hurt you. Next exhibit, civility in the courtroom. Bob and I looked far and wide for examples of incivility in the courtroom. There's a lot of it out there. This particular this video that we're about to view is from the state of Florida, and it's between a public defender who is standing next to the podium with his client next to him, and the judge who is on the bench, who is out of the frame. A jury is being impaneled, and you can see the jurors there. And it's remarkable what takes place. Give a listen.
All right. If you want to set for docket setting, set for docket setting. I'm not waiving in any case. This is an emergency.
If I had a rock, I would throw it at you right now. Stop pissing me off. Just sit down. I'll take care of it. I don't need your help.
No, you know what? I'm the public defender. I have a right to be here, and I have a right to stand and represent my clients.
If you want to fight, let's go out back, and I'll just beat your ass.
Apologies, 1 second. Would you like me to replay the video? I apologize.
That's fine, yeah. You're almost to the end anyways.
I think we're at the end.
I think that's it. The only thing at the end that you miss is the judge walks back into the courtroom and everybody cheers. So I'm not exactly sure why they cheered for the judge in that situation. But there is an absolute amazing example of incivility that has really started from what we've seen here based on the judge's initial comments and decorum. And it's important to recognize that the Supreme Court order that came down in December of 2020 also addresses the rules of civility as they pertain to members of the judiciary. And again, you may want to familiarize yourself with that as well. But here is a significant example of a judge who has just crossed the line and invited the public defender into the back hallway to engage in a fist fight. There's other examples similar to this on YouTube, and it's remarkable how many are out there. But it just goes to show that members of the judiciary are not exempt from bad behavior either. And you've got to position yourself and structure yourself. So if you find a situation where you're in one like this, you've got to have some idea as to how you're going to handle it, and you need to think through it before it occurs. Bob?
What's our next slide?
Court's responsibilities. There may be one more after that. Yeah, there it is.
Okay, so the judiciary has a unique responsibility. Apart from being neutral, it sets an example or a tone for the matters that are before it. And I know from growing up on motion day, watching patient judges who endured all sorts of things, but kept their poise. Their mannerisms were thoughtful. They didn't roll their eyes. They didn't shake their head. They didn't demean anyone. Obviously, very hard to do when challenged by certain individuals who can't help but annoy or anger. But the premises that we're advancing about important principles and structuring oneself, these apply to those judges who might be in the audience. And it isn't meant to be a criticism. In fact, it's the opposite. It's to commend and celebrate those who are able to do it, because there's probably no more frustrating job than that of a judge faced with unprepared lawyers, lawyers lacking civility, inept presentations, rambling, unfocused arguments, sitting in the pews in the back of the courtroom watching it. Sometimes I don't know how judges have managed, but nonetheless, their responsibilities are enormous. And that's what we need, and that's what we expect, and that's why it is so crucial that these principles we espouse, endorsed by our Supreme Court and other bodies of note, we suggest that contemplating that which is before you is important, and structuring oneself for it is critical.
And let me just go back to that last slide, Chris. I think everybody saw that, but that is an excerpt from the civility principles promulgated by the U.S. District Court for the Western District of Michigan. There's virtually an identical one in the Eastern District as well. But this is just a reminder of the court's responsibilities to attorneys and litigants. And as Bob said, that can be a tall order depending upon the case and the lawyers involved. Okay, next slide. Finally, we want to end by talking about applications and outcomes and benefits from being civil. And there are many. Bob and I were talking about this over the weekend. It really does help to structure yourself so you are civil at every chance you can be. It promotes good relationships, and that is key and critical. As we think back over our careers, there's so many beneficial relationships that help all of us in our jobs and our professions, and certainly being uncivil works against that. It also helps in networking with other people. If you're civil, if you're kind, if you are a person of high integrity, that follows you, and there are enormous benefits that come with that. Bob, how about you? outcomes, benefits from that?
There are many. It's of overwhelming benefit to you as members of our profession to manifest civility. We are a small community, quite frankly. In your practice area, you will come to know most of the key people within your region and perhaps within the state of Michigan and maybe beyond. And as they come to know you and watch and observe that which you do, those who are civil and civil in all the ways we're talking about, with integrity, with conscientious actions, with preparation, with anticipating things and responding to them appropriately. These seemingly meaningless intangibles at the moment will translate into the reputation you will ultimately have or you already have. And your word is your bond. Doesn't happen overnight. You might have to settle for trust but verify. But the point is, that which you are becomes readily apparent. And if you have structured yourself with key principles, your reputation will follow in time and be evident to those who work within your practice area and come to rely on you even as they oppose you. And you cannot diminish the advantages that this brings. For example, you want an adjournment. You need additional time to prepare something. You might need to ask for some change in the structure of what you're working on so that you can take advantage of newly found information. It could be any number of things that you would request, and those who are the most civil are most likely to get those requests honored. It may, however, be more important than that. You may have a client who has a significant problem, and while you're trying to fix it, you're going to have to use the currency you have as a well-respected individual with a glowing reputation to ask for the kinds of accommodations your client may need. If you're a jerk about it, let me expand that. If you're a prick, if you're hard-nosed, if you're an ass, are you going to get the kind of accommodations you will need to benefit the needs of your client? Answer, not likely. The point being that as you think through what you want to achieve in a particular case or in your career or both, think through how you apply yourself to a given case and then focus on how it benefits your client and see if you can achieve an outcome that is enhanced by how you carry yourself, how you are a civil and decent lawyer with honorable principles. These things can be woven into outcomes in countless ways, whether it's the dollar value of a case, whether it's a win or a loss on a motion or the case. There are any number of things that can benefit from the demeanor you carry, the way you speak, and the way you appreciate your opponents and evidence respect for them in the process that they too have to advance for their clients. All these combined together enhance the potential for meaningful benefits and outcomes for your clients. And after all, that's your real goal and objective in your professional life.
Next slide. Yep, I think we've covered that one. How about the next slide? And the one after that. This is a good quote from William Shakespeare in 1590. And do as adversaries do in the law. Strive mightily, but eat and drink as friends. That says a lot. And finally, perhaps the most important slide of all for today is always to remember the golden rule. Sometimes it's difficult, depending upon the situation you're in, but it often, almost always, is the best response. Remember the golden rule. Bob, anything else?
No, I want to thank folks for attending. As we began at the outset, we're very concerned about where our profession is headed. And we did not want to have a program tonight that just said, go read the rules, honor them, and everything will be okay. We wanted to expand the thoughts and the thinking that people may have when they listen to this kind of presentation, because our focus is on what we can actually do for ourselves and those who are important to us in the profession to make it a more civil and rule of law based profession. Tom and I have big concerns. The organizations we belong to echo those concerns. And we hope that whatever questions or comments or concerns you have might come to us or others in the profession who think that these are important issues.
Chris, I think that's it on our end.
Thank
Thank you so much for giving this opportunity to do this.
Of course. Is there any questions? There was a comment, I'll repeat, a very nice presentation. The most moving point to me was the explanation of the interrelationship between ethics, professionalism, and civility on reputation and professional success. So I do think that summarizes well the program. Are there any questions? Feel free to put them in chat or unmute yourself and we can go ahead and answer those questions.
Chris, I don't have a question. I just want to thank Bob and Tom for coming tonight. And I know I showed up a little bit late, but I really appreciate your presentation, gentlemen. It's good to see you.
Alex, good to see you. Thanks.
Much appreciated.
And as a reminder, for those who weren't able to make it exactly at 5 o'clock, because I know we did start early, this presentation is recorded and the full video will be distributed to everyone who RSVP'd. So I am not seeing any questions at this time. I would like to then again thank our wonderful presenters, Mr. Behm and Mr. Riley, for their wonderful presentation, as well as ABOTA for co-hosting this event, and hope that everyone continue to support the negligence law section, ABOTA, and the ICBA. For those ICBA members, we do have our benchmark conference this weekend, and we are looking forward to seeing everyone there. So unless there is a final question, I will go ahead and stop the recording, and everyone may take off or stick around for a few minutes. Thank you, everyone.